In this final session on the topic of enforcement of international law, I will outline the role of the UN Security Council. I will address some of the criticisms directed to this body for not doing enough or for doing too much. Case studies that will illustrate our explanations will include sanctions against Iran and Iraq, as well as current counter-terrorism measures. As we will see, the role of the Security Council has evolved through practice, or if you want, it has established its own customary rules of operating beyond the provisions establishing its competencies in the UN Charter. I will contend that some of the criticisms that are usually directed to the Security Council respond, partially at least, to a lack of understanding about the rationale of the powers of the Security Council and what kind of reasoning they are meant to serve. It is important to bear in mind the overall composition and functions of the Security Council before focusing on its enforcement powers, especially its competence to impose sanctions. Both the Security Council and the General Assembly are intergovernmental organs where political negotiations take place regularly. Plenty of other cooperative approaches to implement international law are facilitated within these bodies. For instance, we have seen that the Security Council has used its binding powers to call upon parties to negotiate resolutions to conflicts. Once again, I want to highlight that we tend to pay more attention to coercive forms of implementation, but they coexist in practice with other cooperative approaches to enforcement. The Council is one of the 6 principal organs of the UN Charter. 5 remain operative. We have seen that already. I already explained in another lecture that the Trusteeship Council ceased operations in 1994. The Security Council is composed of 15 state members and is in continuous session. Establishes the basis for the unique composition and powers of the Security Council that have been extended in unforeseeable ways in practice. Chapters 5 to 8 of the Charter deal primarily with the Security Council institutional positions and functions. Then we have a relevant provision also in Chapter 14 that addresses the International Court of Justice. These powers can be summarized as first, identifying the existence of a threat to the peace or act of aggression. Second, intervening in disputes when necessary to facilitate that parties settle them by peaceful means. And we have already seen a bit of this when we looked at settlement of disputes. Third, imposing sanctions. Fourth, authorizing the use of armed force. And finally, Article 94 of the Charter allows the Security Council to decide on measures or recommendations to enforce a judgment of the International Court of Justice at the instigation of any party to a court case. This way of instigating or forcing implementation of a judgment has never been used. It's a power that has never been used by the Security Council. As we are about to see, the powers of the Security Council under these main rubrics have changed over time. Other powers not clearly falling within the competencies established by the Charter have also been exercised and have faced different levels of contestation. According to Article 24 of the Charter, the Security Council's main responsibility consists in maintaining peace and security on behalf of all members of the United Nations. Its decisions are binding to all states according to the letter of Article 25 that I have reproduced here. Remember that the Security Council is composed of 15 states, 5 of them permanently represented and 10 elected. By the end of September 2021, the elected members were Niger, Tunisia, Kenya for the African group, Mexico and St. Vincent and the Grenadines for the group of Latin American and the Caribbean, India and Vietnam as members of the group of Asian and the Pacific states, Estonia for the Eastern European group, and Ireland and Norway for the group of Western European and other states. This means that the Security Council geographical distribution is as follows. You have 3 African states, 2 Latin American and the Caribbean states, 3 Asian and the Pacific states, 5 Western European and other states, plus 2 Eastern European states. The Security Council extraordinary composition and powers have always been the object of criticism. I will address both criticisms that address the features of the Security Council that were designed, that were conferred by the Charter, as well as other criticisms that address other roles developed by the Council with no clear basis on the articles of the Charter. When the criticisms affect powers that are foreseen, that are established in the Charter, it is often the case that the Security Council is accused for not acting when it should, mainly because its actions are restricted by the veto powers of the 5 permanent members. However, for actions without clear basis in the Charter, many commentators have accused the Council of the contrary, doing too much. In brief, the Security Council is often blamed for not using fully the powers it possesses while using others that it does not. For instance, the Security Council has created temporary tribunals to prosecute individuals responsible of international crimes in the context of war crimes that took place during the conflicts in the Balkans and Rwanda in the 1990s. It has also created peacekeeping operations not foreseen as such in the UN Charter, a topic that we will see as part of our lectures on international humanitarian law. Because the system of collective security foreseen in Chapter 7 of the Charter could not be implemented, the Security Council has established the practice of authorizing the use of armed force by other states, rather than deciding or coordinated international actions involving such extreme measures. Again, there is nothing in the letter of the Charter providing this competence, a competence to authorize the use of armed force, to the Security Council, but it has been accepted in practice, and it can be considered one of the powers of the Council attributed to it by customary law. We will also see a bit more about the use of armed force and the Security Council when I record the lecture on the use of armed force. Let's start with a quick overview of the powers that find their basis on the Charter, focusing on the Security Council composition and the use of sanctions. Composition of the Security Council determines its decision-making and has been a thorny issue since its creation. The Security Council's main responsibility is to identify and to address situations that threaten peace and security. Decisions of the Security Council are adopted by 9 votes in favor, and they require the concurrent votes of the 5 permanent members when the decisions are of a non-procedural matter. In other words, for substantial rather than procedural matters, the P5, the permanent 5, have a veto. The permanent 5 are many times referred to as the 5 veto-wielding powers. The determination of whether a matter is procedural and therefore not subject to the veto powers is itself a non-procedural matter and therefore subject to the veto. In brief, it is ultimately the 5 permanent members who decide when their veto apply by exercising what is, in practice, a double veto power. 1, to decide where veto apply, and 2, to then exercise it. The veto powers of the P5 and the composition of the Security Council are clearly not geographically representative and confer extraordinary powers to a very small minority. This is the object of constant criticisms and numerous failed attempts to reform this system. The question of the equitable representation on and increased in The membership of the Security Council has been on the UN General Assembly agenda since 1979 and continues to be frequently addressed in that forum without significant progress. Let's move now to the powers of the Security Council to enforce international law. We have already referred briefly to the role of the Security Council in the settlement of disputes when covering that topic in another lecture and another video. As I have also advanced, the Security Council has never used the powers conferred by Article 94 of the Charter in order to enforce judgments of the International Court of Justice. Article 39 establishes the leading role of the UN Security Council in adopting collective measures to address situations that may threaten the peace or constitute breaches of the peace or acts of aggression. The Security Council has the monopoly to decide when a situation is a threat to peace and security and what measures should be adopted. Here is where the veto of the 5 permanent members becomes fully relevant and where many criticisms to the Security Council can be found. Articles 41 and 42 provide a list of measures that the Security Council can adopt if it considers a situation may threaten peace and security, including sanctions such as embargoes or blockades. Article 41 refers to measures not including the use of armed force, from cutting diplomatic relations to embargoes and blockades. This has been used as the basis for the creation of criminal courts to prosecute international crimes. As I have mentioned, this has been criticized by those who consider these articles as not enough legal basis for the creation of tribunals. On the other hand, Article 42 refers to measures involving the use of armed force. The founders of the United Nations designed a system by which the Security Council will have military troops at its disposal. However, states have never agreed on how to implement this system. The failure to do so has resulted in a practice by which the Security Council authorizes other states to take actions involving armed force. Summarizing, the Council has been criticized over the years for not doing enough or doing too much. Those criticisms have been linked to the veto powers of the 5 permanent members, accusing the body of paralysis when they have been unable to reach an agreement, or accusing the body of acting beyond its powers when it has developed tools that were not foreseen in the UN Charter. The criticisms to veto powers disregard that the Security Council was not meant to be a representative body. The veto power and composition of the Security Council obeyed to a totally different logic, to prevent the outset of a third world war by ensuring that the countries that were most likely to start it will never use force without the agreement of the others. This logic might be obsolete and in need of reform. However, the veto powers are a major obstacle for this reform, because states with veto will veto the reform. In any case, when the Security Council stops a particular intervention, this can be interpreted as paralysis, or it can be an effective tool to prevent escalation of a conflict. The authorization of armed force or sanctions have devastating consequences, and the existence of important checks and balance before resorting to them is necessary. In addition, veto powers have been a big obstacle to reach agreements on sanctions. Concluding, the criticisms to the Security Council directed to the democratic deficits and lack of representation of this body often ignore the rationale for the permanent membership and veto powers. The United Nations was established after World War II with the primary objective of saving succeeding generations from the scourge of war. The prohibition of the use of armed force to settle international disputes was established for this purpose, and the Security Council was conferred with the unique responsibility to maintain global peace and security. Outside the confines of self-defense, the use of armed force could only take place if the states most likely to provoke a third world war were in agreement. So the main criticisms to be directed to the Security Council is probably not that state members with a veto have used it. preventing more uses of armed force initiated by states with nuclear capability and whose actions were particularly dangerous if they actually led to an armed confrontation between other states matching their military capability. The current key weakness, in my opinion, of the Security Council is that veto-wielding permanent member states with the primary responsibility of upholding the rules governing the Security Council have repeatedly and openly broken the rules and justified their actions with ill-founded arguments. This has had a profound impact on the legitimacy of the Security Council and the United Nations as a whole. Why will other states with no veto power respect a regime that is not respected by those who are its guardians and who enjoy, for that reason, extraordinary powers? The first blatant violation of this was the NATO intervention in Kosovo in 1999, repeatedly characterized as illegal but legitimate, following the impossibility of securing a Security Council authorization that was opposed by Russia and China. The military intervention in Iraq followed suit in 2003. On that occasion, the memoranda prepared by the British professor Greenwood, who will become later on a judge of the International Court of Justice, played a significant role in providing legal cover for it, ignoring the clear lack of endorsement by the Security Council. In 2013, the UK also published its legal reasoning to support its right to unilaterally use armed force in Syria, an action that was blocked by its own parliament, but the UK was justified. In 2017, the US resorted to military action in Syria without even trying to provide legal varnish for its actions, despite adverse domestic pressure. The practice of both countries, the UK and the US, put their geopolitical interest ahead of their responsibility to maintain peace and security and the institutional system of which they are primary custodians. It is difficult to see how the institution can ever recover from these attacks to its legitimacy and power that have come mainly from those with the most power within it. So, however, the role of the Security Council, and I want to underline this, and even the veto powers, seem to have been positive in preventing a global international war. It is very worrying that the institution is losing all credibility while there is nothing alternative to replace the Security Council in the horizon. Let's see now what paralysis means when we refer to sanctions specifically. During the Cold War years, between 1945 and 1990, the powers of the Security Council were virtually frozen. By 1990, the Security Council had only imposed sanctions on Rhodesia and South Africa, since the rejection of the apartheid regime was the only issue enjoying enough consensus among states. The end of the Cold War changed this, and a wide range of countries have been targeted by sanctions imposed by the Security Council. As Gavin Sullivan reminds us in his highly recommended book, The Law of the Least, the Security Council has been very flexible in its interpretation of what constitutes threats to peace and security. Sanctions have been used for the promotion of human rights, restoring democratic leadership, and furthering arms control. Progressively, the sanctions of the Security Council have targeted non-state actors, reorienting the interstate focus of collective security. UN actions have also been triggered by violations that are internal to states entering spaces that were traditionally considered as internal affairs and therefore protected from UN interference. The utilization of armed force or sanctions has devastating consequences, and the existence of important checks and balances before resorting to them is necessary. A better system than the veto power is necessary, but the veto powers are probably better than nothing, as I just have explained. obviously provided that states with veto power respect the veto themselves. Attempts to find a better solution have proven largely unsuccessful. The most serious challenge to the veto powers to promote a better functioning of the Security Council is the so-called responsibility to protect that was codified in paragraphs 138 and 139 of the 2005 World Summit Outcome document that was agreed by all heads of states and government that year in the General Assembly. The heads of states and governments affirmed that they had the responsibility to protect their own population from genocide, war crimes, ethnic cleansing, and crimes against humanity. In addition, they accepted that this responsibility had a collective facet they had to uphold through the United Nations using the powers conferred to the Security Council. Some countries have supported an understanding of the responsibility to protect doctrine that will imply removing the veto powers of the 5 permanent members when acting with the aim of protecting populations from genocide, war crimes, ethnic cleansing, and crimes against humanity. However, this interpretation has not been accepted and will require for its implementation at Security Council level a reform of this body that, again, as we have already seen, continues to seem unfeasible in the near future. The R2P, the responsibility to protect doctrine, has failed to change the applicable rules governing the Security Council, and it does not offer, at the moment, a legal basis for intervening in a country when that country fails to protect its population, if that intervention violates other rules of international law, in particular the rule prohibiting the use of armed force. However, it has some symbolic strength in reinforcing the idea that the states members of the Security Council have a duty to act when confronted to situations endangering peace and security. For instance, the human rights experts acting as mandate holders of the so-called special procedures of the United Nations Human Rights Council reminded the Security Council of that obligation when the body failed to reach any decision to react to the conflict between Israel and Palestine in May 2021. In summary, R2P continues to have a symbolic value, but it has not changed the legal basis of the use of armed force. Now to the criticism that claim that the Security Council is acting beyond its powers. Another set of criticisms directed to the Security Council accuse this body of acting beyond its powers. For instance, this is the case regarding the competence of the Security Council to create the International Criminal Courts for the former Yugoslavia and Rwanda. While clearly rooted in generally accepted practice that can be considered customary law, there is no clear legal foundation for the Security Council powers to create peacekeeping operations or to authorize the use of armed force. We cover these issues again when addressing the use of armed force and international humanitarian law, apart from what we have already said on these topics. Now, I am going to focus on the legislative role the Security Council has arrogated itself in more recent years, using as main example its counter-terrorism activities and the so-called intelligent sanctions. Understand the actions of the Security Council that we are addressing, and now we must contextualize them. In the 21st century, the response to terrorism by the international community of states and the United Nations has been shaped by the so-called 9/11 attacks. On the 11th of September 2011, several attacks orchestrated by the terrorist group Al-Qaeda against different targets in the United States of America became the deadliest terrorist attack on American soil in US history. About 3,000 persons died. While the attacks were coordinated by Al-Qaeda from Afghanistan, this was an operation that was planned in many different locations. The scale and nature of the attacks prompted an immediate international response in solidarity that facilitated the first ever action of NATO in self-defense. This is the context. attacks of September 11, terrorism was mainly treated at UN level as an issue by the General Assembly, and the discussions were focused on agreeing on a definition. The Security Council dealt with the specific acts of terrorism identified as a threat to peace and security. These were the case, for instance, after the bombing of the Libyan Pan Am flight over Lockerbie in 1988, or the attacks to buildings in Moscow in 1999. After September 11, the concern over definition changed, as well as the Forum on Terrorism became primarily treated as a threat to peace and security, and discussed and addressed within the Security Council. One day after the attacks, the Security Council approved Resolution 1368, calling states for collective action to bring perpetrators to justice and to prevent and suppress future terrorist attacks. The resolution also referred to the right to self-defense, a significant move in endorsing the use of armed force against terrorist groups behind these attacks. It was also a bold action in terms of decisions of the Security Council punishing non-state actors. A few days later, another resolution, Resolution 1373, compelled a state to prohibit activities supporting terrorism. This meant that the states had to legislate and implement measures to punish financial transactions on behalf of terrorists and freeze the assets of terrorists and their supporters. States had to implement other measures such as extra border controls. Until September 11, sanctions of the Security Council were mostly circumscribed, as I said, to specific states, to specific events. Other states had to respect or cooperate to implement these sanctions that aimed at mitigating the threat to peace and security that they represented. Resolution 1373 was totally different. It imposed on all states changes to their own legislation to be able to implement the measures required. This is the kind of commitment states traditionally undertake through treaties or customary law. The Security Council was able to adopt such a resolution under the immediate pressure of the September 11 attacks, but this decision opened the door to others in the same vein. The Resolution 1373 also created the Counter-terrorism Committee to overview its implementation. In 2005, a new resolution, Resolution 1624, called UN member states to extend the measures covered by Resolution 1373 and to legislate at domestic level to prohibit activities that incite to commit acts of terrorism. States became also obliged to deny safe haven to anyone with respect to whom there is credible and relevant information giving serious reason to consider that they have been guilty of inciting or committing acts of terrorism. Therefore, the Security Council has attributed itself the role of creating rules of general nature that oblige all states using a shortcut. Because Security Council resolutions are binding according to Article 25 of the UN Charter, this means that a reduced group of states, mainly the 5 permanent members, are deciding new international obligations for other states without their consent. Modus operandi has now been used beyond sanctions involving terrorist activities. The lack of clear legal foundations to the power of the Security Council to legislate creates great insecurity about the scope of this power. When the Security Council creates new obligations, it is not clear how these obligations apply or when they cease to exist. Let's see this through the example of the Iran deal on development of nuclear capability. I plan to prepare another video explaining this example in more detail, so stay tuned to the channel if you are interested. For now, suffice to say that on 24th November 2013, the 5 permanent members of the Security Council plus Germany reached a historic agreement with Iran, agreeing in Geneva the Joint Action Plan in relation to the development of nuclear capability by Iran. The plan involved the progressive lifting of sanctions on Iran in relation to its development of nuclear capability if Iran met some conditions. This agreement was not a binding treaty. The parties to the agreement did not follow the steps we have seen they need to follow for a treaty to become binding. In particular, they did not sign it. Furthermore, the agreement was in clear contradiction with former resolutions of the Security Council imposing sanctions on Iran for its enrichment of uranium activities. So, the parties could not sign a treaty that was contrary to resolutions of the Security Council affecting all states. Based on the 2013 interim agreement, a joint comprehensive plan of action, complex one with 159 pages and 5 annexes, was agreed by Iran and the Permanent 5 plus Germany on the 14th of July 2015. This agreement remained non-binding by itself. However, the Security Council approved the resolution 6 days later, that is on 20th of July 2015, endorsing the agreement and establishing the termination of the provisions of previous Security Council resolutions on the Iranian nuclear issue, so terminating the conflict with former resolutions of the Security Council. As you can see, again, a few states used their exorbitant powers in the Security Council to make an agreement that looked like a treaty but was not a treaty, but that became binding de facto by its endorsement by the Security Council. And my last statement is not completely accurate, because the language used by the Security Council has led some commentators to deny that the agreement is binding. But the opposite interpretation is possible too, and other authors have supported it. Complicating things further, in May 2018, the United States unilaterally withdrew from the agreement and reimposed all the sanctions previously lifted. It is unclear what withdrawing from an agreement that is not binding means. Withdrawing unilaterally from obligations derived from a resolution of the Security Council is definitely not possible. So the United States cannot withdraw from a Security Council resolution. As the Iran deal demonstrates, the creation of multilateral obligations with intervention of the Security Council creates problems without solutions, because the Council was not meant to act as a world legislator. In the scenario under analysis, some of the questions raised include: is the endorsement of the Security Council and its call for implementation of the agreement the same as making the agreement binding? Can a state withdraw from an agreement endorsed by the Security Council resolution in this particular scenario? Do rules of international responsibility apply? So, for instance, if a state stops complying, can the other states affected by the resolution of the Security Council stop complying too? The Vienna Convention on the Law of Treaties does not provide for termination of treaties via withdrawal if the agreement is silent. So, what regime applies? Is the withdrawal treated as analogous to a suspension of an agreement? An analysis of the Joint Comprehensive Plan of Action and the Security Council resolution does not answer all these questions, or can lead to different conclusions and interpretations. Evolution of the Security Council practice over time is not only related to the scope of the measures adopted and its new assigned role as universal legislator, especially in the field of countermeasures. At the end of the Cold War, and as the Security Council found more facility to adopt sanctions and other measures to address situations identified as threat to peace and security, the impact of the measures also became more evident. So, for instance, when Iraq invaded Kuwait in 1990, the Security Council authorized the use of armed force against Iraq and a full regime of total sanctions against the Iraqi regime. The suffering these sanctions brought about were the focus of a lot of criticism. To alleviate this outcome, the Security Council introduced the Oil for Food program, by which it established exceptions to the sanction regimes that in practice meant that Iraq could sell oil in exchange for food, medicine, and other humanitarian needs, under the control of the United Nations. The program was tainted by allegations of corruption, hence my choice of cartoon for the slides. And although it seems that the scope of the mismanagement of the program was less than the accusations directed to it, several investigations proved that at least some of the corruption allegations were well-founded. It became clearer than ever that total sanction regimes were unsuitable to pursue their objectives, at least without punishing severely innocent civilians. The total sanction regime imposed around the same time on former Yugoslavia revealed similar outcomes. These experiences resulted in a move towards so-called intelligent or targeted sanctions. In a way, the Oil for Food program is one example of this strategy, the articulation of a sanction regime that minimizes collateral damage inherent to economic sanctions directed to a whole state. While other forms of smart action, sanctions are possible, the tool that has prevailed in particular is to punish specific individuals rather than territories. The practice has been prolific in the context of counter-terrorism measures, and many of the sanctions of the Security Council have targeted specific terrorist groups. The design and implementation of intelligent sanctions avoid the devastating humanitarian consequences of comprehensive sanctions, and they have become progressively sophisticated, especially in combating financial support for terrorism. So in principle, the ethical, theoretical, and practical benefits of this move are obvious. However, the impositions of sanctions against individuals and non-state actors rather than states are contrary to well-established human rights and other rules of international law, even when we ignore that the targeted individuals by these sanctions are mostly targeted not for something they have already done, but for what they might potentially do in the future. The Security Council has responded to these criticisms with different reforms, including the establishment of a focal point for delisting in 2006 and the Office of the Ombudsperson to the ISIL, Daesh, and Al-Qaeda Sanctions Committee, where targeted individuals can request to be removed from the list of persons to whom the sanctions apply. Still, the existence of these targeted sanctions continue to be in open conflict with international standards on fair trial and due process, among others. And here we finish our session on the Security Council that has covered, as you have seen, many topics.